3914.
House Bill 3914, and recognize Representative Click to explain the bill.
Thank you, Mr. Chair and members. In recent years, there have been a number of news accounts of some high-profile guardianship cases. Cases in which has made the news and made the public more aware of some of the processes that occur in probate courts regarding guardianship. I filed House Bill 3914 to strengthen some of the due process in those proceedings and provide protections and rights to persons alleged to be incapacitated by court-initiated guardianship proceedings. There are several groups around the state that have been working together through some of these issues. And I do have a committee substitute in Ledge Council that I'm not yet able to lay out. But it's, I think, very important in some of the cases that have been covered in the news that there are more due process rights for the individual. I think that our bill will allow the incapacitated to have the right to petition the court for the order to be set aside. A number of these cases, while we want to protect those who are truly incapacitated and might be at risk of being abused or exploited, the number of the cases that have made the news have been people that perhaps left you with the impression that they didn't really need a guardianship. And that's a pretty intrusive procedure. They lose their civil rights, where they live, who they can associate with, making medical decisions. And I think that we definitely need some reforms in these areas. I have several witnesses that are here to share their experiences with guardianship and expound on part of the discussion that led to this bill, and happy to answer any questions and reserve the right to close.
Well, we'll see if there's any questions for Ms. Click. Okay, if not, we'll just go ahead and call the witnesses we have.
Thank you.
Ms. Click. And I know some of the witnesses have had to leave, and we're sorry about that. But and we, once again, I'll say this for the last time, we apologize to those who have had to wait around to testify, but we're glad you did. We have Sherry Johnston here in favor of the bill.
Good afternoon. I'm Sherry Johnston, and I'm on the bill, or for the bill. And I'm going to pass out some literature, and when you look on the very last page, you're going to find some writing in red right here on the back side. And these are all associations, some associations that are associated with guardianship services in Texas. And these are the gentlemen and gentleladies and associations that write our statutes in probate court. Nobody that I know of that were citizens or had any input into the manual to the probate court. And one thing I thought was very interesting was I found this on Harris County website and also on the, I think it's GBCC or JBCC website. Harris County is a corporation. Harris County and Galveston is the only ones I know of that the guardianship program is a corporation. So I thought that was very interesting that we have corporations that are being ran in Harris County that has the right for a judge that's been elected every 4 years in probate doing wills that has a right to put people in guardianship. I think that's very wrong. Another thing I would like to ask is that a person that's going to be alleged incapacitated, I think it should be mandatory, a right that they have a trial by jury. Even on an investigation, this is such a important issue that our citizens are going through. My mother went through, never had process. She got served going through rehab through a process service. She's in guardianship. I think that anything that has to do with our constitutional rights should be a trial by jury. Everybody gets a trial by jury. And I would ask Mr. Guy Herman or Terry Hammond, you take the hundreds of thousands of guardianship cases that's been throughout the years that Texas has done. I asked them to produce 10 trial by juries that these people that have been put in guardianship have had. There's not one. And for a corporation to be able to take care or strip my mother of her rights, I think is a horrible thing. And also it says in this bill that the judge, the court-initiated guardianship, all that consists of, from their own records, is the guardianship referral that they get when somebody refers somebody in probate court. And on this referral, it asks for the name, the date of birth, the prior address, the doctor that signed this, and it also wants to know how much money they have. I think that's crazy. Then it goes on and then for the physician's report. It's all a package. The doctor fills it in, and nobody that I have seen in probate court has ever testified in court because they're too incapacitated to show up in court. And another thing, it says that the right has the alleged person has a right to set it aside. My mother told him to set it aside, told her attorney ad litem that was gave to her, never had the opportunity because she said it was in her best interest not to. So, thank you for your time.
Thank you, Ms. Johnson. Members, any questions, Ms. Johnson? I just want to say good to see you again. If you please tell our friends at Snuff Ridge hello.
I will. I tell them that I met Mr. Clarity, and he says hello.
All right.
Thank you so much.
Thank you. All right. Ms. Betty, turn it off. Thank you. Ms. Betty Lucky. And again, Ms. Lucky, if you would, your name, who you're with, and your position on the bill. For or against or on the bill.
I am Betty Jo Lucky from Cleveland, Texas, and I'm for the bill, and I'm representing myself. And I apologize, I'm very tired. I got here, lack of experience, I got here at 7:30 this morning. So, I'm a resident of Liberty County. My grandmother, Willie Jo Mills, who entered guardianship in Harris County, probate 4, against her will, and I'm here in her honor requesting that you pass House Bill 3914 as a start to reform the guardianship program. If this law would have been enforced when my grandmother was forced into guardianship, perhaps she would not have suffered or died when the judge refused to protect her as a protected person under Texas guardianship. And that's all I have.
Thank you, Ms. Lucky. And thank you for taking the time to be here. And I know it's important for your testimony. The members, we really do appreciate those of you who care enough to be here and offer your testimony. So thank you for being here.
Thank you.
All right. So next we're going to call Ms. Debbie Valdez. Good to see you again, Ms. Valdez. And you know the drill.
Yes.
Name, who you're with or testifying on behalf of, and your position on the bill, for or against or neutral.
Well, good evening. My name is Debbie Salinas Valdez, and I'm the director of GRADE. Sorry, I'm tired. GRADE is a grassroots advocacy and resource organization for families of the elderly and disabled affected by our state laws on guardianships. We give a voice to the unseen and the unheard. Thank you for the opportunity to testify on House Bill 3914. I am in favor of this bill. Since the creation of our organization in 2009, we have received numerous phone calls from all over the state, specifically from areas in Texas where probate courts are doing business with guardianship services providers that the Estates Code refers to as guardians. And more than likely what you all believe are guardians. We really need to begin focusing on the difference, because family guardians are not the only guardians who abuse, neglect, and exploit their elderly and disabled family members. As a matter of fact, if you think back 10 years or even maybe 7, there was very few complaints about guardianships. Every state, especially Texas, has all systems in place to protect our vulnerable Texans, including a guardianship. While you are hearing complaints about guardianships more frequently to this extent, is that we need reforms is because Texas does not have a system in place to protect our most vulnerable from the guardianship services providers, other than the judge who appointed them. A family guardian can be removed with a snap of a finger in most cases if protection is needed. However, a guardianship service provider is much greater protected than the elderly and the disabled. They are cloaked with protections from civil immunities. As a matter of fact, so are guardian ad litems. Guardian ad litems are court appointed to act in the best interest of the proposed ward or ward. Protections of civil immunities are important to this role because his or her opinion is and has been what is enforcing innocent, unsuspecting elderly people into guardianships, whether they need one or not. The disabled are also being represented by guardian ad litems after they become a ward. And after a person becomes a ward, they no longer have any civil, constitutional, or human rights. They become property, and here is a description in the Estates Code that identifies the purpose and construction of a guardianship. Section 1001, and I'm not an attorney, but the way I interpret this, is laws applicable to guardianships. To the extent applicable and not inconsistent with other provisions of this code, the laws and rules governing the states of decedents apply to guardianships. I and the members of GRADE are in support of House Bill 3914. Know that GRADE members are the many throughout Texas who have been removed from their loved ones, and many have lost their loved ones as a protected person because of the opinion of one or two people investigating whether guardianship is needed or not, believing that they have probable cause to act in the best interest. I'll be finished in just a minute. Without clear and convincing evidence, without considering the preference of the ward or proposed ward, and most importantly, without being required to consider the due process rights of a person. I have a little bit more. Can I finish?
How much is a little bit?
About another paragraph. Just a small paragraph like that.
You've been so patient, we'll do one paragraph.
Thank you. A person, a living person, a vulnerable human being whom we are all charged with protecting, whose lives are being dictated by third parties with the approval of the judges who appointed them under this law. I ask you to please pass House Bill 3914. It will complement Chairman Smithy's Bill 39, House Bill 39, that begins with real reforms to guardianships by giving the actual person who guardianships were created and intended to serve an additional opportunity of due process rights protections, hopefully so that they don't fall into the hands of strangers who are appointed to decide where they live, who can visit, what happens to their financial resources, whether they live or die, while family is forced to watch without any control of stopping it or having a fair chance to protect their loved one and their estates administered in probate courts under the laws and rules governing the estates of decedents. Thank you very much.
Thank you, Ms. Valdez. Members, any questions? Thank you, Ms. Valdez. Let me just say this as you make your way back to the chair. I personally, it seems like we've had so many issues and bills have been brought about guardianship issues. And the point's been made very well by a number of you, and yourself included, that the elderly issues, this is going to be a more important issue as our population ages. So I just want you to know, even though sometimes we're walking in and out, and you may not think we're listening to what you're saying, I think we're hearing as a body very seriously that these guardianship issues are something that we need to get in front of and really start focusing on. So I appreciate Representative Click bringing the bill and others who have brought bills on this issue. So please know that you are being heard, that this is something that we are all focused on. We all are going to get older, Lord willing, and we all have elderly parents and family members, so this is something that we do take very seriously. So thank you for your time, and thank you for being here with us late tonight, and go home and
thank you very much.
Bed.
Thank
all
you.
Right, thank you. All right, next we've got Mr. Michael Easton. I'm sorry. I'm sorry. Before we get there, we've got Susan Norman. No, why have you got me on the wrong one here? Oh, Christy Hood. And I'm sorry, Ms. Hood, I wasn't skipping on purpose. There was just a different name highlighted.
Yeah.
There you go. I got you now. So, Ms. Hood, you know the drill.
Yes, sir.
Name,
and you know what?
Number.
I only have 4 paragraphs. I'm going to be real short.
4 paragraphs. Okay. Well, we look forward to those 4 paragraphs. Please proceed.
Hello, my name is Christy Hood. I'm representing myself, and I'm for this bill. I'm passing out a great big package which you may have already seen, but I'm only going to talk on 4 basic little things. And I do thank you very much. In the past, I've heard that probate judges have come up here to testify and say that bills like this one tie their hands. Their hands need to be tied. It should not be easy or convenient to strip an elder or a disabled person of their liberty, assets, and dignity. The elderly and disabled should get at least the same protection under the law as a criminal. First, there is probable cause. An anonymous call to UPS or DADS alleging elder abuse that then generates a report that, without investigation, lands the elder or disabled in a probate court does not meet the criteria for probable cause. A doctor in a hospital who reports that an elder refuses their advice to go to a nursing home and instead insists on going home where he does have 24/7 care. The doctor then reports this person's refusal to follow their advice to APS to cover his butt, but that doesn't meet the criteria of probable cause. A family member who reports to APS that there is a suspicion that the elder's power of attorney holder, both medical and financial, may be taking advantage, does not meet the criteria of probable cause. Having an affidavit signed, even if it's by APS, is probable cause. Without that affidavit, it's just a mill to get these people in. The second issue is burden of proof. It's supposed to be the state that must prove that the elder is incompetent or incapacitated. Currently, the way it's working, am I done that? Man, I'm slow. Elder has to prove their competence, sometimes over and over. If a judge isn't getting what he wants, he has the discretionary power to keep trying. This translates into an elder be stuck in probate court forever, feeding all the court-appointed lawyers. I'm going as fast as I can. Until proof is presented to the court that an elder or disabled person should not have, until proof of incapacitated is shown, they should not have their pocket picked by a court-appointed attorney. If the case is in a county that doesn't have a statutory probate court or a court investigator, the county should have the duty to hire an outside investigator on a case-by-case basis to be paid by the county. They should not be an ad litem anything, but an adjunct or auxiliary court investigator. It should be a true investigator, not a lawyer. Can I finish my last paragraph?
We're down to 1 paragraph.
Yes.
All right, Ms. Hood, I'll make you a deal. If you'll tell me who the judge is you designed the cover of your bill about, I'll let you finish your last paragraph.
Don't you think that's going to get me in trouble?
No, I'm just teasing. You give us that last paragraph, and then we'll move on.
Okay. I mean, can I come and tell you afterwards
Yes,
and not on the... Okay.
I would be most
All right.
enlightened. Thank you.
Okay. Last, there is due process. The elderly are not criminals, yet criminals are allowed to testify on their own behalf. The alleged ward is not. Criminals are allowed evidentiary hearing. The alleged ward is seldom afforded that opportunity. Criminals are allowed jury trials. The alleged ward is very, very rarely afforded that opportunity. The passage of this bill is so very important, not just for the elderly and disabled of today, but for you. And I was going to point to Chairman Smithy, and I was going to tell him that the way the law reads right now, a disgruntled voter could make an anonymous phone call to UPS, and he could end up in probate court.
Now, Ms. Hood, are you ad-libbing outside your paragraph right now?
Yes, but I thought of it early.
Okay. All right. Well, that's
I'm done.
Thank you for your testimony. Thank you for being here again tonight.
Thank you for listening.
Members, any questions? Thank you. This time I'm going to get it right. We're going to go to Miss Susan Norman. Did she leave? Okay. Michael Easton also left. Is that correct? That brings us to Ms. Elizabeth Mason. Ms. Mason, are you here?
She left. She had to go back to Houston.
And by the way, if anybody else wants to leave, that'd be fine. Let me see. We've got Ms. Virginia Pritchett. Thank you. Glad you're here. Thank you for staying with us.
Thank you so much.
And Ms. Pritchett, if you would please give us your name, who you're testifying on behalf of, yourself or an organization, and if you're for, against, or on the bill. Thank you.
Yes, my name is Virginia Pritchett. I'm from Palo Pinto County, Mineral Wells. I'm testifying as an individual, and I'm testifying for the bill. And if I could, I would like to testify on behalf of my elderly friend that passed away while under state care. This is hard for me to talk about, but I'm going to if it's okay. Denise Tai, my friend, was an immigrant from Switzerland. She was a manager of a French bank on Wall Street in the 1950s and a very wealthy lady who never wanted to go to a nursing home. Denise was diagnosed with a bladder infection which was curable but causes dementia problems in the elderly. Her wealth would prove to be her downfall. Her doctor wrote a note asking for home help for her and sent it to Adult Protective Services. But after Adult Protective Services received it, they forced Denise out of her home. She was rarely able to see her beloved pets or her friends again. She was carried out of her home screaming, "I don't want to go," with neighbors looking on horrified. Although she never wanted to live in a nursing home, Denise was forced to spend the next 2 years of her life in a nursing home simply because she failed to make out a will, which was not intentional. She could have afforded to pay for 24-hour home help until she died had she been given this chance, but this option was never given to her. Her money was divided between a cruel guardian attorney and others. The attorney wanted to kill her pets even though they were not ill, simply because he was sick and tired of dealing with them. This guardian attorney, I asked this guardian attorney if Denise could go home, and he informed me that Denise's property was going up for sale no matter what. When I questioned the cruel manner in which Denise was removed from her property, the guardian told me that he had seen people handcuffed and strapped down, and it was clear to see the manner in which my friend was treated was of no concern to this man who was supposed to be helping my friend. My friend was denied visitors for Christmas 2 years in a row by her guardians. She was denied visitors the entire Christmas week. The reason being personnel could not sit with her as they would be with their own families. Once my mother and I went to visit Denise on an impromptu visit. She had been taken to a hospital, not expected to live. No one had been called, not even her only sister. My friend lay alone, dying. I complained to the politicians' offices and went to media about the neglect of my friend because complaints to ombudsman and hospital personnel were getting absolutely nowhere. Department of Age and Guardians soon placed visitation restrictions on Denise, punishing her and the friends who stood up for her. The weekend my friend died, those unreasonable restraints were in place. Myself, her sister, and her sister's caregiver were made to wait 3 days for an appointment to see Denise, even though medical personnel knew she was dying. My friend ended up dying without her sister or her friends with her as a result of Department of Age and Guardians' poor decision in not lifting this visitation rule. This guardianship law may have been passed to help people, but instead, in my opinion, it enables the greedy to take full financial advantage of the elderly. My friend was never able to spend a day in her home again because she had money. If you can imagine what she went through, what I just described. It was no word to describe how sad this was. Nobody deserves this. This lady came to the United States to make this country her home. And I'm sorry, but she saw some of the worst of United States law. Thank you, sir.
Would you be available to, some of the members have any questions about that particular situation?
Absolutely. Thank you so much. Thank you.
Any questions, members? If not, we appreciate you waiting as long as you did.
Well, thank you, sir. I appreciate the kindness. Thank you very much.
I apologize that you had to wait.
That's okay. Thank you.
Thanks.
Thank you.
We have Lori Burnett. Is missing. We understand some of the witnesses had to leave. We have Dennis Borrell.
Mr. Chairman, committee members, Dennis Borrell, Coalition of Texans with Disabilities, for the bill. So since the last session in the interim, a number of disability organizations, individuals with disabilities, parents groups, and attorneys met and worked on a number of ideas to create, if you will, alternatives to full guardianship so people with disabilities could retain as much decision-making over their own lives and as many rights as possible. And those included groups like my own and Adapt to Texas, the ARC, Texas Advocates, our GRADE Friends, Mental Health America, Texas Parent to Parent, the Down Syndrome Association, and others. So a very wide range of disability organizations worked through these others. The idea is to come up with smart diversions instead of always going all the way to full guardianship. Now, this particular bill, let's speak about this particular bill. You know, as these other alternatives were like cutting people off the path on their way to full guardianship, this one is you're getting really very, very close to full guardianship with the court-initiated guardianship. So the protection in Representative Click's bill is right at the end. You know, let's have an out. Let's make sure that that individual really is incapacitated, and let's give them those rights to perhaps refute that they need to be in guardianship. That's why this is so incredibly important. We had an opportunity to discuss this with Judge Guy Herman earlier out in the hallway. He had originally registered in opposition to this bill. After discussing the committee substitute with him, he has changed to neutral, and he asked me to come and let you know that the statutory
I can't let you testify for him. So
okay, well, I'm just saying that.
Appreciate you.
All right, but the statutory probate judges, to my knowledge, are okay with this. Okay?
And that's good. Yeah,
and I'll let it go at that. I understand.
You've gone.
Understand.
You can certainly go where you've gone. I just don't want to endanger the bill by, you know.
Appreciate that, and thank you for pointing that out to me, Mr. Chairman. With that, I'll end my remarks.
Well, thank you, too, for waiting. Is there any question, members? Thank you for being here, and we'll may be talking to you, too, about working with you. So we have Craig Hopper here. Is Craig Hopper here still? And let's see, did Judge Herman leave? Yes. Okay. And also Kelly Smoot.
Good evening, Chairman Smithy, members. My name is Kelly Smoot, and I represent Americans Against Abusive Probate Guardianship, a national organization based out of Florida. And we do support this bill. We feel it imperative that before any state strips any person, disabled, elderly, or for whatever reason, strips that person of all constitutional and civil rights. Yes, I'm just wanting to make sure I've got everybody's attention because this issue is so important.
Now I've got you listed as testifying on the bill.
Yes,
so
for the bill.
So you're not testifying for or against right now. You're just on the bill, correct?
No, I have changed my submission from when I registered with you, and I'm testifying for the bill on behalf of AAAPG, Americans Against Abusive Probate Guardianship.
Well,
I have changed that information from when I registered.
Okay, and I don't doubt you, but just in case it hadn't shown up, is it okay with you if the clerk changes you to for the bill?
Absolutely.
All right, good.
Of course.
Okay.
Please.
All right, so go. Yeah, that's fine. I've got you on, but we'll move you to for the bill.
Okay. Yes. So this is such an important issue because the actions that occur in a guardianship case strip the individual of their constitutional and civil rights. And they not only strip that individual, but they render the individual's family unable to have legal standing to do anything to protect their loved ones. And so this is as the gentleman just pointed out, this is the last chance just before a guardianship is instituted to say, well, wait a minute, let's at least make sure this person knows their rights, has had their rights, and has had a chance to respond. Because as I understand it now in the state of Texas, you can be put under a guardianship based on an anonymous order, and you might not ever know that this has happened until someone shows up at your door to take you away. And that is completely unacceptable in America, I believe. And I hope you agree and find it and will vote for this bill.
Okay.
Thank you.
Any questions for Ms. Smoot? Well, we appreciate you being here, Ms. Smoot, and we appreciate you waiting to testify as well. Do we have anyone else here to testify for, against, or on House Bill 3914? If not, Ms. Click, you want to close?
Thank you, Mr. Chair and members. I close, and thank you for being here tonight and hearing our testimony.
Okay. Any other questions? If not, if there's no objection, the chair will leave House Bill 3914 pending. And Ms. Click, you know, we've had a number of guardianship bills. Several of the witnesses who testified and I have testified on other bills, so the committee has become, I think, very, very aware of this issue, and we appreciate your bill. And hopefully the legislature will do something along these lines. I know we all see the problem that exists and want to move forward on that, so to do some good on it. Thank you very much, and thank you for waiting out on the committee.